morning, everyone, and welcome to Mediation, the New Possibilities Hour. It's June 11th, 2020, and we are delighted to have as our guest, as part of the Will Work for Food project, Micha Star Liberty, the president of the Consumer Attorneys of California, one of the largest and most influential organizations of the plaintiff's bar in the world. Micha practices at Liberty Law in Oakland, California, and what a great name for a law firm that is. She handles a wide variety of personal injury, employment, and other cases, all from the plaintiff's side. The Consumer Attorneys of California has named her Street Fighter of the Year. In 2015, she's also been on lists of the most feared plaintiff's lawyers. So we all better listen very attentively. And of course, we're here as part of the Will Work for Food project. There's no charge for these webinars, but we do ask you to contribute to a food bank if you like what you see. So with that, it's very important for us as mediators to understand the perspectives of the plaintiff's bar. So Micha, why don't you please begin with any introductory comments you would care to make, and then I'll have some questions, and then we'll open it up to questions from everyone. It'll be a great hour of education, and we'll raise a lot of money for food banks. So please.
My real name is Micha Star Liberty. I've been a plaintiff's lawyer for almost 20 years, and I want to tell you just a tiny little bit about my background because it will help instruct our conversation here today. So my first job after college was as a White House intern in Clinton's first term. I then moved over and worked for two different members of Congress. One, Mel Watt, was the first Black man elected to Congress since Reconstruction from the North Carolina area. And the second congressperson that I worked for was Anna Eshoo here in the Bay Area. And I mention that because my first love is politics. And I was determined to go to law school, get my law degree, and go back to DC to write policy. And this 20-year plaintiff's career was a tangent, because once I learned that people could, in the civil realm, assert civil rights on behalf of people who were brutalized by police, once I learned that I could help the disabled community protect their rights when they're discriminated against or abused, and once I learned that there was the ability to hold men, women, and children who were sexually abused as children or as adults accountable in the civil realm, I knew that's what I wanted to spend my daytime doing. But I still continued to work through the political process. And the Consumer Attorneys of California is at its core a political organization. We do MCLEs, and of course there's networking, but we have a very strong team of lobbyists and advocates who help us raise money for political candidates who are pro-consumer and pro-worker here in California, as well as once folks are in office, we help write legislation and lobby it. We are about to get our revisions into the governor's budget, which is going to go up for a floor vote on the 15th. And there are aspects that will impact our court system here in California, and I'm happy to talk about that. But my response and our organization's response to the COVID crisis was a political one, and really we focused our attention on lobbying the governor because he was the only one who had the emergency powers to act. And then once he transferred power to our Chief Justice, we worked with our judicial council and the court system to help advocate for both plaintiffs and defense perspectives to try and help the courts get reopened.
So as mediators, we're very curious to know, what will litigation look like going forward? Because litigation, at least in the civil and commercial world, where most of us on this call spend our time, is intimately related to the world of litigation. So Are courts opening? Will they be functioning? Will there be schedules? Please, what is your view of the civil litigation world going forward?
Again, kind of start with the history of how we got where we are in this moment to really understand where we are in this moment and in the proper context. So the first court to shut down in California was the Contra Costa County Superior Court. And it wasn't until 2 days later that our governor, Gavin Newsom, issued the statewide shelter in place. The consumer attorneys knew the kind of cascade effect that was about to happen. And before the governor entered his shelter in place, we had already started lobbying him, because what happens in emergency situations and when courts have to close for a state of emergency, a natural disaster, or something like this, the first impact is always on folks who don't have a lot of access to justice options to begin with. So we knew what was going to happen was they were going to have to figure out how to continue the criminal justice process, and that if there was time, attention, room, and a safe way of doing it, on the civil side, the only types of cases that we were going to see continuing would be unlawful detainers, to make sure people don't get unhoused during this time, and then criminal justice like civil situations, for example, domestic violence, restraining orders, or those kinds of things. So because the organization had been through the economic downturn in 08 and 09, the reaction to 9/11, when everything shut down, we had a little bit of experience and we're ready on day one to start lobbying. So we started lobbying. It took about a week, and we were able to get Governor Newsom to transfer emergency powers to the Chief Justice. So we finally had the courts now in charge of what happened to the courts. And we tried really, really hard to get some emergency orders in place. So, and again, remember, we're just focusing on civil, so that whatever we could do remotely, civilly, could continue. And there was some success. The problem in California is that we have 58 counties, so there are 58 different superior courts, and under our state constitution, each of those courts is allowed to and does operate completely independently. So what we have been trying to do is wrap our arms around all the different presiding judges to get them to come up with a coordinated and consolidated response to getting civil hearings to happen remotely, to protect statutes of limitations that were running during this shutdown, to try and prioritize statutory preference trials when we are able to do trials. So unfortunately, there is no true power, because of our constitutional makeup, for the Chief Justice to come in and say, all 58 counties, you need to reopen, and you need to do it this way, and you need to do it that way. So as practitioners, we are left with checking wherever we have cases. And in today's day and age, most of us who have bigger practices are practicing in 10 or 15 different counties across the state. They all have different emergency orders. They're all opening up at different times for different types of business. And it is incredibly stressful, and feels like, you know, your first year of practice when you thought everything was a malpractice trap. So we're going around trying to figure out who's doing what. One of the things, and I think this is one of the best services that CAOC has provided during this time, is that we are tracking and tweeting out and posting on a COVID page on our website all of the updates as the courts around the state are opening up and issuing orders. So there's one location for people to go to try and figure out what's happening. Now, one of the problems is courts are saying they're open for business. Courts are saying they're accepting ex partes, but there's no one there to process the papers when we're filing them. And the clerks aren't getting back to us because they're not there. In counties where you have to get a reservation number to file a motion. So it's very, very messy, as I've said, and we're still continuing to work to try and get more funding for the courts, so that there can be a real focus on holding remote hearings. And you asked about trials.
Yes.
So courts are starting to issue new trial dates, and it's a big question mark. Our Judicial Council issued a 68-page report just last week with different ideas and different options about how we can have jury trials in the COVID age. You know, of course, one option is to have jurors be remote. No one who's ever tried a case, no real trial lawyer wants a jury in another room, right? We want to be there. We want to make eye contact. We need to get feedback from body language. The idea of having our jury impaneled at home on a laptop, or, you know, even socially distant in another room that's large enough to hold them is troubling and problematic. I also just saw that ABOTA issued a plan, I think it was just yesterday, and I had skimmed through that. So there are different ideas, but honestly, there's two things that I want to say. One is nobody wants to be the first test case to go to trial in the middle of a pandemic. We are not going to get the same reaction from jurors that we might from the plaintiff's perspective. We may not be able to seek or receive the type of financial award that a client deserves, because folks are dealing with a lot. And politically, what's happening in this country has kind of changed the tone and the focus. And, you know, it really feels like day after day, there's some new hit revealing cracks, if not complete breaks, in our justice system here in the US. The other thing that I want to say is that it's important to know that as we have done our work, we're doing it in conjunction with the California Defense Council and seeking feedback from CalABOTA. Because really, this isn't a plaintiff's or defense issue, it's an access to justice issue. And all, as practitioners, we're trying to do is to make sure the courts are allowing us to work through our clients' legal disputes in a timely manner. But delay, delay, delay is what we're seeing every single day.
We have in the mediation world largely transitioned to online platforms, chiefly Zoom, and many of us have been kind of pleasantly surprised at how effective it can be, the ability to look at people's faces up front, close up all the time, viewing facial expressions better, even if we can't see other parts of body language. Do you think that there might be some benefits to trial lawyers from having that kind of view of jurors?
I think that if you come to a crisis like this with the perspective of, we're going to get through this, we're going to make it work, our goals are all the same, and that's dispute resolution and access to justice, I think you can find that people will pivot very easily and kind of lean into where they are. So I have found, you know, there are kind of two camps in the lawyer world when this thing hit. There were people who were completely freaked out, fired half of their staff, broke their lease, and just hunkered down for the worst. And then there were people, foolhardy people like me, who were hiring and trying to expand and, you know, doing things to give back to our legal community, because we will get through this. And how we choose to go through it really is kind of up to us. So I think that technology is a wonderful addition to a profession that frankly was not quite up to speed. I always laugh that we're the only profession aside from realtors who still fax things. I mean, there's just no reason for this. There are ways to communicate that are cleaner, faster, more environmentally friendly, and more effective. So I think a lot of good, if you're looking for a silver lining, has come out of this with respect to modernizing and communicating and interacting with the courts. For example, there were judges who were so fed up here in California with their presiding judge telling them they couldn't do any official work, that they set up their own Gmail accounts and were issuing kind of tentative rulings on things, you know, from a Gmail account because they wanted to continue to do their job. I think Zoom, you know, Microsoft Teams, Skype, all of these different applications that are available to us. There's one I just learned about, Blue Jeans. Our court here in Alameda County is using Blue Jeans. They're great. There are a lot of, when I was growing up as a lawyer, what we called warm body hearings, some case management conferences. On the criminal side, there are a ton of warm body hearings, but you know, it's not always effective. It's much easier and cost effective to have a 3-minute case management conference over Zoom than it is to get in your car, spend an hour fighting traffic, find parking, go in, and then you sit there. We have started to use, well, we've been using court call for a while in California, but I'll tell you, that was a political fight when it happened. So we really had to rally our troops just to get the courts to allow us to have case management conferences by court call. And then we had to fight again to have courts allow us to appear for law and motion matters. There are going to be things that we want to show up in person for. You know, if I have a huge motion, a dispositive motion that I'm arguing against, I want to be in the room. Because there are still technology issues. You know, when it was just the phone, you couldn't see the judge's demeanor or reaction. Sometimes people speak over each other, and we have the same types of issues with these video conference services. There are glitches sometimes. Everyone is working from home right now. So, you know, in our neighborhoods, I can tell there are some days where everyone's busy and doing Zoom calls because, you know, the connectivity, internet kind of waxes and wanes. But, you know, I think that there's a lot that we can do if we're more effective. We've started to do in my office all kinds of things to modernize and to be able to function 100% remotely. And, you know, as COVID was impacting people, even before the shutdown, we were working almost exclusively remotely. And I'll tell you, as a team, we feel a lot more connected because we do an hour-long Zoom meeting every single day. Sometimes we have to shift the time because of scheduling things, but it's wonderful because when we were all in this office, it's easy to get distracted, pulled into meetings, someone's in a deposition or whatever. You don't have that amount of time. So that's a real blessing to team building and cohesiveness and strategizing rather than a once a week or you know, once every 2-week meeting to talk about cases. So there's a lot of good that's come from this. But there's a lot more work that needs to be done. And I'll tell you, I really cannot believe how poorly our court system responded to this crisis. You see court systems all over the country where there's weather. We don't get a ton of weather in California, but my friends who practice in Michigan and Illinois and Wisconsin, they didn't miss a beat because they're used to blizzards and, you know, complete snow days. So they I think it was the Wisconsin court system, when there was, a little bit before the kind of shelter in place period of this crisis started, they recognized what was happening. They ordered a bunch of professional Zoom licenses. They did training, and their court system was up and running. But in California, we have all these fiefdoms, and it's just, we're the heart of invention and technology. Just, a few miles from here in Silicon Valley, this is where everything is coming from for the most part in terms of advancement. And we are so far behind the times. And, it's shameful because our clients suffer.
The conventional wisdom has always been that if the greatest catalyst for a settlement is a firm trial date. And firm trial dates are both a thing of the past and a thing of the future. And also, defendants may well simply have more important things to do with their money, at least in the short term, such as making their payroll and paying their rent, and settling a case if they can put it off for a while may be a good idea. So what is your experience? Are cases still settling? Are they settling differently? Are different cases settling? Please give us your perspective.
I think it depends on the case and it depends on the defendant. So my practice is broken down into kind of two components: personal injury and employment. And we do those areas in the traditional context. But our main focus is on helping men, women, and children who've been sexually assaulted or sexually abused. We also represent special needs children and adults when they've been physically abused at the school, in a home that they're placed in. So we are suing and going against entities that have insurance, or public entities where there's either a joint powers authority or they're self-insured. So I think if you're going against a mom and pop type of business, you have the same problems that you would have normally, which is there any ability to recover? Are they a judgment-proof defendant? So that struggle is real and has always been there. I think with respect to defendants that are insured, not much has changed. We've settled some pretty big cases against public entities in the past 60 days, 70-ish days, where there are joint power authorities having to make decisions at different, layers of coverage. We were told things like at the mediation, which was all done by Zoom, we have to get the joint powers authority to approve this, and that could take until August. We have to get the school board to ratify, and the schools are closed, the whole district's shut down, or whatever the case may be. So we kind of were buckled down and have to have those clients understand how long this could potentially take before we could even do a minors compromise petition. But we were pleasantly surprised. Both of the two cases that I'm talking about on behalf of special needs individuals were able to be resolved. The JPA got back to the defense lawyers quickly, and so did the school boards. So it seems like everybody else, aside from the court system, is able to stuff and get things resolved. I think that the other thing that's really important at CAOC, we've got just under 4,000 members. A lot of our members are solos and small firms. They're doing auto accident cases, those kinds of things with limited policies. And we were very concerned when this hit that, just like in 2008 and just like we saw after 9/11, there would be insurance companies who always size up the size of the firm and the type of work they do and how much trial experience they have and all of that stuff. And they throw that into the mix. We were concerned that they were going to get impacted in a disparate way, and that cash flow would be an issue for them. Their ability to represent their clients would be impacted, and that they would get lowballed, frankly. So what we did was take a look at our Department of Insurance and what types of responsibilities and ability the commissioner had to communicate with the insurance companies that certain aspects of a plaintiff or claimant can't be taken into account when making an offer. So Ricardo Lara, our insurance commissioner, issued an advisory essentially saying it is an abuse and, you know, bad conduct, and there will be ramifications, insurance companies, if you do things like, you know, negotiate based on a potential claimant or a claimant being behind on rent, or you know, an eviction process has been started, or there's, you know, mortgage issues, or they filed for bankruptcy, or they're claiming unemployment, or whatever it is. So we were able to give the ability for our lawyers to cite these rules that are in place, saying you may not basically employ these abusive tactics where you're using information to drive down your offers and to try and, you know, lowball people and force them into settlement. Because it's really, what do the kids say? It's not a good look if you're trying to kick someone while they're down, right? These folks are hurting, and we're now officially in a recession. And the last thing that we should be doing is helping people abuse claimants when they don't have any options. So there are different ways that we've tried to counter and protect not just our members, but the client base that they serve, which is really all Californians.
Let me ask you, you mentioned your own experience with video mediations. We would love to hear your thoughts and reactions. What went well? What do you wish people would do differently? What advice do you have, both for advocates and for mediators, about how to conduct mediations online?
I have loved my Zoom mediation experiences. I think it's a better use of time. We were actually able to get a case. It was the second mediation, a very contentious case. A 6-year-old autistic girl was physically abused by her school bus driver. And the 27 minutes of abuse were caught on video. So the case went through the criminal process before we filed, and it was national news because it was so disturbing. And so it's hard to get those kinds of cases resolved right away. So we had already spent, you know, 12 hours with this mediator, who's a retired judge, about a year ago, and it really went nowhere. And so it was the right time to circle back, and we were able to get it resolved in, you know, about 5 hours. So not even a full day of mediation. So for the lawyers, it's good, I think, and I've heard good things. But even in-person mediation for the lawyers is a good exercise. I think the client experience is not the same, though. So, you know, as things open up a little bit better, I would continue to agree to do video conference mediations, but I would want to be in the same location as my client, because it's, from the plaintiff's perspective, this is the first time, you know, these parents have ever been through this process. Their child was horrifically abused and will forever have, you know, whatever the ramifications are, however they manifested, PTSD, and if they have autism, their abilities cognitively to process that trauma is a lifelong struggle. So, you know, this is a very emotional and difficult process, and watching it like you're, you know, watching it on TV, and not being able to be in the same room as the mediator or the same room as your lawyer, I think it's makes it more emotionally difficult. It's hard to get them kind of to buy in. You know, part of what we do in the plaintiff's room is try and bring our clients along. So just like you're going from room to room advocating the other side, we're doing the same thing. But the message that we have to continue to send is this is a business decision for them. And this is, you know, your heart and soul. And so trying to bridge that gap and bring them along is so challenging remotely.
Well, give us some other tips. You know, this is quite an insight into what goes on, because as mediators, we are committed to helping good lawyers get the best results they can and under the circumstances for their clients. And we owe equal obligations, of course, to the plaintiffs and defense side. I think you can give us some tremendous insights on what we as mediators can be doing better or differently, or maybe there are already some things we're doing well that you can reinforce for us.
Well, I think that you know, people who go into mediation are just predisposed to be coalition builders and problem solvers. So y'all have the fundamental baseline skills already. And you know, we pick mediators and the personalities and the way they do mediation based on the case. So, you know, if I know a mediator is going to be very transactional and very business-like, I wouldn't pick them for a case where I know the parents are going to be in tears for 70% of the mediation. So, you know, I think we bring it's our duty to kind of bring the right people to the table. I think if there were some advice that I would give in that respect, it's, you know, having a conversation before mediation, not about positions and value and all of that, but what tone does the client need? What emotionally, where is everybody, and what's the reaction going to be to X, Y, or Z? You know, if things are starting to go left in a mediation, I take myself out and go meet with the mediator repeatedly and try and to protect the clients from conversations that's so business-like. So I think that's maybe another tip. If there is real pushback, or you need to have a dollars and cents kind of shorthand, you know, we all speak the same language. They're not even conversational in law. So I guess just be conscious of that and have conversations outside of their presence, but explain kind of why that's going to happen. The other thing we deal with sometimes, and I've seen this when I've been brought into cases kind of at the last minute to help with mediation or trial. Not every lawyer has good client control in terms of their emotion. So I'm trauma informed. The lawyers who work on my cases with me, my team, they're trauma informed. And so we know how to gauge where our clients are and speak to them in a way that helps open communication and not shut it down. So if anyone is going to do these types of cases, abuse, sexual assault, I know you guys can strike a deal in any context. How people process trauma, because they're re-experiencing it throughout the mediation, and that can shut things down and things go sideways very quickly. So a lot of communication. I think the other thing is, one of the things I've seen mediators do that's not super helpful in my context, is as they're trying to get to know the clients, asking them questions about the assault, for example. So when we have an intake with a sexual assault survivor, we don't talk about the abuse or the assault until we've built a rapport. And you can't build a rapport in one mediation session. So, you know, you shouldn't try, and you really shouldn't get into those kinds of things because it's going to re-traumatize them.
It's an interesting and kind of awkward situation because would seem almost trivializing the event and dismissive to say, you know, did you see the ball game on TV last night or something like that, assuming ball games come back, you know. So
Right.
There's a concern that it's almost disrespectful to make the kind of small talk you might if you were at a cocktail party, and yet getting right in and, you know, talking right about the events is too rough. What's the middle course? What's a good thing for mediators to do?
I think acknowledging that they were harmed and what happened to them was significant, and asking them how they're holding up that day, and once you get to know them a little bit better, how they're feeling generally. But you know, we are I'll tell you, this is a tangent, but I tried a wrongful death case years back, where I represented the parents of a 22-year-old who was riding a bike and was run over by a food delivery truck, one of those big old trucks, and killed. And we were on a break, a lunch break or something with trial, and the lawyers were talking at one end of the conference room table and eating about evidence, pretty graphic and gross evidence. And we were so, you know, into what we were doing because it's the heat of trial. We've got a very short break. We have to go back in and cross-examine an expert or whatever we're doing. And we realized after a couple of moments, because the whole energy in the room changed, that the parents were on the other side of the table, just completely traumatized and in tears, because we can eat a turkey sandwich and look at autopsy photos. They cannot. And so you really have to kind of remember when you're asking questions to fight the urge to go back into the judge mode or the litigator mode, where you're just trying to get the evidence as quickly as you can and make, you know, figure out what you're going to say in the other room or whatever. So spending as much time with someone, asking them open-ended questions, giving them authority and permission to tell whatever they want to tell you about their story, I think accomplishes the same goals. But one of the biggest fears at this point where we are in this country, after the Me Too movement, which had some interesting impacts on litigation. But one of the biggest fears of someone who's come forward and reported sexual abuse or assault is that they're going to be called a liar, and they're going to be questioned about why they didn't come forward right away if they didn't, criticized when, you know, some detail has changed. We've seen it all before, right? This is played out very publicly. And the thing that's important to know is that the brain writes trauma memories in a very different way. It's not linear. You know, when I have a client who is saying, I can't remember this piece of it, I can't remember, you know, they're frustrated with their own brain because they can't remember, I'll just say, well, just tell me what you do remember. And you'll hear the weirdest details. Like, I remember as I was being assaulted, there was a painting on the wall that looked like blah, blah, blah. But they can't tell you how they got from, you know, the club that night home, or how they got into the cab, or who they called first, if it was the police or their mother or whatever. So just kind of understanding how the information comes out naturally from a trauma survivor is an important piece. So I'm not suggesting like just talk about, you know, the ball game or sports, but find some common ground, and then open it up and give them the power to tell you what they want to tell you.
Thank you. Let's turn to a very mundane question. You talked about these kind of back channel whispers between lawyers and mediators. And indeed, if a mediator does get something wrong or a little off track, it's the biggest favor you can do to us to let us know so that we can make a mid-course correction, because we're committed and devoted to giving the best service possible. And everybody sometimes makes a mistake. So when you're in person, it's relatively easy to grab a mediator on their way to get water, coffee, on their way to or from the washroom, whatever, and say, you know, hey, come here, I got to talk to you for a second. In the online environment, we don't have those corridors, and we're each using the washroom in our own home. So how do you do it in the online environment?
Well, there are ways to have confidential chats. When you break out into rooms, that's a little beyond, you know, when I'm in the zone, that's a little beyond what I can deal with technologically speaking. But all the mediators have given me their cell phone numbers.
Mm-hmm.
And so I'll text them, or we'll have you know, a conversation, and you can put your screen on, you know, stop video and mute yourself, and, you know, sit right where you are and have that confidential conversation with the mediator.
So it's important to have that back channel and to bring your cell phone with you to the mediation, to text or call the mediator when you do need to have those deep sidebar conversations. So before we open it up to questions from other people, there's one other important area that I wanted to raise with you. That is the question of case evaluation in an era that is very different. The country, whether you're a liberal or a conservative, a Democrat or a Republican, whether you watch MSNBC or Fox News, I think everybody agrees the country is a pretty different place than it was 6 months ago. And we all question whether jurors will be evaluating cases in the same way, whether different kinds of cases will go up or down in value, or are we just in complete terra incognita in terms of how to value some cases? And I think it puts into play the whole question of evaluative mediation, and whether a mediator can any longer say, oh, I've seen 100 cases just like this, when things are just so different. What are your views on that?
Things are very different, and we are in, you know, a whole new world. We don't know when courts will really open back up, and as I've said, the trial bar, none of us want to be the first ones to go, because we don't know all the same kind of knee-jerk reactions to the jury selection process and assumptions we make based on whatever characteristics we're looking for or trying to weed out. The same rules just don't apply. I think that, you know, using jury verdicts is still a sound starting point. But the reality is, if clients are wanting to settle because for whatever reason they need the money, they've lost their job. I mean, one of the challenges my clients face is they have to have health insurance, because a lot of them need access to psychiatric treatment. You know, they have suicidal ideation. And so getting them and into treatment and making sure there's no gap in that is very, very important. And so even before this pandemic, those kinds of issues and access to cash flow, if there isn't insurance, all of that comes into our evaluation. So what you're going to see from the trial bar is the same old trial lawyer perspective, which is each case is, you know, a high seven-figure case, and they're not taking a dime below, whatever. And sometimes that is true. Sometimes, you know, you go in and it's a case that you want to try, and it's a case that has to be tried. Um, but y'all will be able to suss that out, whether or not there's a real appetite for settlement or not. I think everyone knows the realities of where we are, and they're taking that into account as they're making the decision even to go to mediation at this point. And when they're, you're starting the phase of the mediation where you're talking about, dollars and cents, I think that it is always helpful for a mediator to pass along real concerns that the defense has, the other side has, in terms of access to settlement funds. We need to know what the real deal is coming from the other room. What can frustrate the purpose and is going to upset the clients in my room is claims of you're never going to get a jury trial and, all of the things that we know are potentials. If those are being hammered, it's going to shut people down in my room because we know how to assess risk. This is our job, actually. And we will be assessing the risk as we're making our counter offers. So I think that can kind of bring down the energy and the spirit of cooperation from the plaintiff side. If all we're hearing is everyone's going to file for bankruptcy, you better take this low dollar offer, you're never going to see any, kind of all of those things, they're just not super helpful.
Okay, before we open it up to questions, is there any last advice you would like to give the mediators online?
I just want to say thank you all for doing what you do. It, dealing with the personalities, not the clients, but dealing with the personalities of the lawyers that you'll have to deal with. I know can't be easy. I know it's not easy. And I will tell you that some of my favorite mediators, we have gotten into some very, very heated debates and discussions during this process. There's one mediator who I use all the time and I adore her. And she and I will sometimes go in a room down the hall so we can each other. But, that's our process and it works for us and I respect her very much. I think if you can remember kind of why plaintiffs' lawyers do what they do, and I'm not talking about the fancy cars and the private jets or whatever that we see from the big lawyers out there, but our rank and file are people who really want to just help people go from a sense of victimhood to a sense of empowerment, and the only way we can do that is get them money. So your participation in that, your help in that regard is hugely important. All the while we're trying to explain to our clients that we know they wouldn't trade whatever the experience was for all the money in the world. So it's this weird, unfair bargain, but it's the best we've got. And for a long while, it was the best system in the world. Right now, things seem a little skewed, but I think that that's helpful, that we're all coming to it from a sense of wanting to help. You, us, the defense lawyers, we are all in this together. And I've been saying this time and time again during this pandemic, there's no such thing as you having a leak on your side of our lifeboat. So, we really should all be rowing in the right direction and the same direction. And I just want to say thank you so much for inviting me. This has been super fun, and I'm happy to answer any questions that y'all have.
Let's open it up. Thank you. This has been a wonderful, informative, candid conversation. Thank you so much. Let's open it up to questions. We have about 10 minutes left, and we have a crowd of this size where we can just ask people to unmute themselves, and please ask your questions.
And Jeff, there are several questions in the chat.
Natalie, since you've been monitoring the chat, maybe you can pose some of those questions.
Sure. So Chantal wants to know which platform allows for caucus rooms with one party to the mediation.
Caucus rooms when there's only one party at the mediation? Sorry, I don't.
I believe that's what she means, yes.
I think Zoom does.
Most mediators think Zoom is the platform that works best for the breakout room function, where we can separate people and mix and match and put different people in shifting configurations at different times.
And there's a really interesting way that I was doing a mediation a couple weeks ago. The mediator was in New York, the other side was in LA. Co-counsel was in Colombia because he got stuck down there before everything shut down. But the client was telling, because the mediator could pull us out of the room. All of a sudden, we would be talking to the client. All of a sudden, we would disappear from the screen.
We're getting a little feedback, so please.
So Micah, here's a question, and I'll just read it to you. Micah, I understand the online dispute resolution and mediation platform may not be the best for cases involving children who have been violated by some kind of trauma, but if the COVID-19 situation does not change, what will you do? How will you face that as a plaintiff's attorney?
We don't ever have the actual victims participate in mediation. There's not the bandwidth, and usually it's they stay home, or now that we're doing Zoom mediation, they're in another area, or another parent or caregiver removes them from the home during the process. But in California, for children to assert their legal rights, there has to be a guardian ad litem appointed. So it's us and the guardian. So it won't really change, anything. We can't put the children through that. And, even when we have disabled adults, there's just not the cognitive functioning, there's not the verbal skills. I mean, a lot of clients, a lot of plaintiffs we have can't even testify because they don't have the capacity to.
Thank you. That was an excellent answer. Another quick question. Have you found that by virtual mediation usage, you've been able to include higher level insurance representatives?
Yes. We have a sample size, I think, of 3. So the data, we're still gathering data. But for the most part, we don't agree to go to mediation unless there is a commitment to bring the highest level of authority to the table. And a lot of our cases, we kind of split them between, depending on the cause of action, between state court and federal court. And the good thing about federal judges is, it's their way or jail. So they'll just order people to attend. Which makes our job a little bit easier.
Okay, and so Micah, one last question in the chat. You mentioned that COVID may have impacted the minds of triers of fact when it comes to awarding damages. We've seen the revenue of businesses severely impacted by COVID. The question is, with that in mind, what are your thoughts as to the future of PAGA claims?
PAGA is the Private Attorney General Act here in California. And we see politically attacks on PAGA every single year. It's kind of the favorite of the folks who don't believe in the tort system and who don't think that there should be any representative actions. So there are 10 to 15 bills introduced every year in our legislature trying to undo, unravel, get rid of all of the rights folks have under PAGA. So it's kind of nothing new under the sun. I will say that in this experience that we're all having together with COVID, one of the things that the anti-PAGA people did was request the governor use his emergency powers to diminish, minimize, get rid of PAGA. So there's this real tension right now. And the governor, I think, has done a fantastic job of kind of making sure he's not legislating by emergency order. So he's declined at this point to sign any sort of orders like that. We did see in a related area, the medical community, doctors, hospital associations, big pharma ask, and the nursing home business groups ask the governor to issue an emergency order immunizing any treatment, care, anything that was, the language was so broad, COVID related or potentially COVID related. So we are, the governor's office said it was going to issue some sort of order immunizing, and the balance that he was trying to strike was encouraging first responders and caregivers to agree to go to work and to help people, with the need to hold people accountable if they make a mistake or intentionally harm someone. We have seen huge problems in the nursing homes here in California, and failure to follow standards. So we see these kinds of attempts to undermine what the law actually is right now from these communities. But like I said, with respect to PAGA, we see these kinds of attempts to, cut back or diminish all rights every year in the legislature, and they're not successful. We kill more bills than we help get passed because there's so many more bad bills out there trying to harm consumers and workers in California.
Janice?
Hi, good morning. I'm gonna ask a quick question and then I have to jump to a 9 o'clock Zoom myself, but I wanted to get your take on arbitration. I know that traditionally a lot of plaintiffs' lawyers would resist, arbitration, feeling that they're going to get, smaller awards because there's no jury and that kind of thing. I am a full-time mediator and arbitrator, and my experience is actually the opposite. If I have I do a lot of consumer arbitration. If I have a consumer that proves their case, they will ring that bell with me. Obviously, if they don't prove their case, then their damages are not going to be existent. But my point is, what is the take or any new take on the plaintiff's bar in terms of pursuing arbitration as an alternative to waiting out the court backlog? Thank you.
Thank you for the question. Well, I like that you said ring the bell. So wherever you arbitrate, maybe I should look you up. No, in all seriousness, this is arbitration has been something that trial lawyers have fought against for years and will continue to. And I have testified time and time again against binding pre-dispute arbitration. I think that businesses and sophisticated individuals, if there are all the other prerequisites met, like there isn't fraud or withholding of information or whatever the situation is, then it's a fine way to resolve disputes. What we're seeing in the younger folk who are coming up, who've been practicing 5, 10, 15 or so years, they don't, this is the first time there's been, a real economic long-term downturn that they've ever dealt with. They're now in their careers on the plaintiff side where maybe they have their own firm or they're a rainmaker. And so they're looking at the bottom line and they're looking at cash flow and, they're kind of holistically viewing the entire process, and they're concerned that they're not going to get a trial date. Or that if they do get a trial date, they're, no one knows how to pick a jury right now or what the juries are going to do because everyone is hurting financially. So it's hard to get a jury to really be as open-minded, potentially, in certain situations, in certain cases. But I feel about the new world of jury selection, the way I feel about trying a case in a very conservative county. If you can prove, like you said, Janice, if you can prove bad conduct and significant harm, you can ring the bell. In the smallest of jurisdictions with the most conservative jurors, because fundamentally, nobody wants anyone to be abused, taken advantage of, harmed. So it really depends. I do have some concern that some of our younger folks are suggesting, because they don't have the perspective or language, they're calling it private justice. And I keep saying, you mean arbitration? Really talking about arbitration here. And they're saying that maybe, they would want to go that route. And so if that's what people want to do voluntarily, I think that's fantastic. The concern is that there be some requirement that if a case is below a certain dollar amount or whatever it is, that we have to go into this arbitration system, outside of underinsured motorist coverage, outside of, areas where we normally see arbitration. In California, we have what's called the expedited jury trial system, which is meant to help with the kind of backlog of civil cases. If it's a claim below, I think it's $25,000, which used to be the Muni Court, Superior Court demarcation. If it's that kind of a case, you can get this expedited jury trial, but both sides have to agree. It's limited discovery, limited days at trial, so people can get in and out more quickly. So people may take that option too.
Okay, Janice, thank you for that question. And Micha Star Liberty, thank you. This was a tremendous hour, just jam-packed with all kinds of insightful and very helpful information. Thank you so much. As I mentioned at the beginning, this is part of the Will Work for Food project. We don't charge for these webinars. If you like what you see, and how could you not with this great hour? If you like what you see, please send in a contribution to a local food bank. We appreciate that very, very much. If you're in a position of food insecurity yourself, we're happy to be able to support the food banks that provide help for people at this time of economic and food uncertainty for so many people. Natalie Armstrong, thank you so very much for organizing the Will Work for Food project and for allowing me to participate with these New Possibilities hours. And Natalie, that's all I have. Back to you.
Thanks so much, Jeff. And Micha, thank you for your really incredible presentation. So lovely to have someone of your caliber provide us the kinds of insight that we really are looking for. Our goal is always to do a better job for our clients and their clients. And so any assistance, any information that we can glean is always a good thing. Micha, thank you so much. We hope that you are safe and sound and staying home and being well during the COVID-19 crisis. Jeff, thanks so much for your professionalism in setting this up. And to everyone who's participated and donated, we really appreciate your generosity. And with that, I'll say thanks so much for having joined us today. Enjoy the rest of your day, everyone. Bye-bye.
Thanks, everyone. Bye-bye.
Thank you.